So if someone wants a copy of a video now, they ask for a CD or some physical.
I don't know that, I'm looking over at Carol, I don't know if that's ever happened, but that would be the process. And really, it's no different than when I ask for a video. They send me down a disc too. Or then the research attorneys, in our case, will upload it into the electronic files that some of us on the court use to prepare for oral arguments in all of the cases.
Okay. Well, as long as we're on video, Ron, you are helping or help champion something we're doing today, and that is video streaming. And I'm wondering if you can talk about that and access to that information for reporters.
Sure. Cameras in the courtroom were first rolled into this room in one case before the Supreme Court in 1981. And we let a public television station do that to avoid the commercial competition bragging rights issue. And when they did that, they brought in a switcher that was probably almost as wide or long as this table and just as wide to be able to switch from one camera to another. Now, on top of that desk in the corner is a VHS-sized camera switcher that's gone from thousands and thousands of dollars to a really reasonable amount. So the changing technology, as well as through the years, a very accommodating Supreme Court as far as being open and transparent, have resulted in now you can watch the Supreme Court oral arguments from any place in the state or the world for that matter, but people sometimes think, well, why would I care about the Supreme Court? Well, school finance rings a bell, and there are other things that suddenly, have captured the entire, or at least a good majority of the adult population in this state and want to know about it. Death penalty cases. So,
and the Phil Klein case is coming before the court next week.
Yes,
isn't that right?
the attorney discipline matter involving a former attorney general of the state of Kansas. I know that'll be probably widely viewed by a lot of people. Just very quickly though, from 1981 to 1983, we had experiments and then permanent cameras allowed at the Supreme Court. From 84 and 85, we had experimental judicial district. We had 4 in 1984, and one of those was the 5th Judicial District, Lyon and Chase counties, and headquartered in Peoria. I remember distinctly the Kansas City Times reporter at the time during our little news conference announcing the experiment said, what would ever happen in Emporia that would bring a TV station? And that very year during our experiment, we had a Lutheran minister involved in an affair with the church secretary that resulted in the murder of
There we go.
his spouse and
We'll take murder. Was there sex involved?
Yeah, absolutely.
Oh, murder of the spouse, yeah. Okay.
Both her
good.
spouses wound up murdered, and meanwhile, I can't remember now, but there was a made-for-TV movie. I can't remember who did it, but Murder Ordained was resulted from that whole thing, as well as I was the PO liaison with the media down there, and we had one reporter from Australia.
Wow.
So, and that's my only analogy here is, well, who's going to be interested in watching a Supreme Court oral argument? Well, I can tell you, you never know. And so long it lasts, and it has taken a lot of time and effort. We do have the equipment and technology in place, and there's a camera at the back and a camera up there. And so far, I don't think it's caused court problems for my court, has it?
No, we keep being told by our lawyer friends that we need to watch ourselves because we don't necessarily know when we're on camera, and it's kind of, an Obama moment where we're not necessarily looking our best. But it doesn't. But it hasn't caused any discussion on our part.
And just for your notes, though, the live stream is available by clicking on our court website, www.kscourts.org, or if you want, you can go to podcast.kscourts.org and get a download for those in the broadcast industry. It's we try to make it as easy as possible for people, media, to grab bites of various proceedings and use it. And really, I think WIBW, I know, has grabbed pieces of it, and I suspect there are other stations. It is a lot less time consuming for the media to grab that instead of bringing in the whole setup for a 30-minute argument.
Fed's not going to do that, huh? Put you on the spot here.
You are putting me on the spot. Well, we're making some inroads. 31 years after Kansas has put cameras in the court, the federal court now has a pilot project called Cameras in Courts, and the District of Kansas is one of those courts that are participating. And in fact, we're leading the country at this point on the number of broadcasts that we've had. But it's a much different situation than what we have in the state court at the trial level. This is a situation where first, only civil cases are taped, and that's in part because the federal rules of criminal procedure have a prohibition against it, so it's going to take an act of Congress to change that. So that was a major impediment. But the equipment is installed permanently in the courts, and it is controlled by the court personnel, and all the lawyers have to consent, the judge has to consent, and then the proceeding is taped and then uploaded to the U.S. Court's website at intervals. We're trying to get them done, after half a day. At the noon break, we would upload the morning. At the evening break, we would upload the afternoon sessions to make it somewhat, hopefully, time sensitive for the media. It's not a great situation. The cameras, we have 4 of them, one on the witness stand, one on the lectern, one on the judge, and then we have an evidence camera. And the way it's presented on the court's website is a 4-pronged composite of those. So I'm not sure it makes great television, but it certainly is a step in the right direction of getting some transparency into the federal court. Federal court's really been under a lot of pressure. Senator Grassley has had some sunshine in the court bills that have gotten to various levels over the past few years. The Ninth Circuit wanted to broadcast their Proposition 8, the marriage issue, and eventually was told no by the Supreme Court. But there is certainly pressure on the federal courts to have more media access.
Okay. Kent, what have you heard here that leads you to have any issues or concerns as a representative of broadcasters in the state?
Well, I have a couple of questions for Justice Biles. And Tim, because he didn't propose these rules and really didn't set any of this up, he knows I'm not taking shots at him. But it just was amazing to me that the federal courts thought they were doing such a great service when they brought this out, but there was no thought about media, because generally media don't cover civil cases. So there were no criminal cases, so there was no chance really for it to be tested. I think it's here in Shawnee and over in Wyandotte. And Wichita, okay. There are reporters from all 3 of those here. Has anybody done a federal case in Sedgwick, Wyandotte, or Shawnee? Okay. And again, this is not, I'm not shooting the messenger here. So that's kind of a concern, and if it takes an act of Congress, then it should take an act of Congress, because if the Supreme Courts of the states, many states, can do this, then it would seem like the federals ought to ought to join in. A couple questions. You kept referring to these as appellates. Now I'm kind of back to the e-filing for just a second. So when it gets to Douglas, Sedgwick, Leavenworth, et cetera, will that e-filing be done at the trial level? So at the beginning of a criminal case? Or are these only things that are filed once it's on appeal?
Oh, no. When we're talking about e-filing and starting, for example, in January in Leavenworth County, that'll be district court filings. And it'll be, depending on how the chief judge sets up the pairing, we're really just testing in January. Let's assume that we've got this date where all lawyers are going to have to start. In Leavenworth County at some point during 2013, all lawyers who want to file a case or file anything that they would normally file with the district court clerk, they will have to do electronically. So there will be a drop dead date. It's just these dates I'm giving you right now are just when we're testing out the software and its integration with the case management system and the document management system. And each of these counties has a variation technically with those components. For example, Leavenworth County has entirely what we call full court, which is the state system. Some counties have been able to do a little bit of their own in case management or document management. And so like Sedgwick County has a thing called FileNet, and so we have to make our software work with it. So and the same with Douglas County. So each one has got its own uniqueness to it, but we're talking about anything at the district court level. And so if at the district court level, if you're in one of those counties, you need to know that you go still, like you do today, to your clerk, and they will have a computer screen for you. They'll have some way for you to be able to access anything that was filed. It's still a public document, and your access will be controlled that way. At some point, we will get to where you don't have to go to the clerk's office, but I don't know what that looks like yet.
Is that, will it be the Supreme Court that will be overriding, now let me change the word, that will be overseeing this to make sure it's implemented in that district court? Is that up to the chief judge of that court? And then my third question is, tell me it's not the same software company that was handling the Department of Revenue's motor vehicle registration.
Taking your last question first, it's not the same company. The e-filing is being done by a company called Tibera. The document management, case management is being done by Full Court. In most counties, Johnson County is different. Sedgwick County's got a little variation. Shawnee County is transitioning over. But under the Constitution, the Supreme Court has administrative authority over the courts of the state. So yeah, it's us, but we're being nice guys about it, and we're respecting, for example, service of process. That's a big issue because in like Johnson County, if you're a lawyer and you file electronically, they take care of everything else, including getting the documents to the sheriff so they can be served on the other party. There are sheriffs around Kansas that do not want that cost or burden or responsibility. And so our system will allow each chief judge and each sheriff to get together and decide how it will work in that particular county with that sheriff. So you can have one of three different variations. So we're trying to look at the chief judge and the local officials to put their system together, and that will cause some variation. But I don't think from a public standpoint or a media standpoint, it'll be that big a deal.
The skepticism comes from the previous panel in that cameras in the courtroom vary by district courts, and that if this were to get to a point where it's really successful for media to be able to utilize this to do their job, that all of a sudden in County X, oh, I can't get this. Well, the judge didn't really require us to do that, and well, he kind of lets us slide on some of those things.
I don't see that with this. I really don't see that. Now, there is one other thing that's probably close to your heart, which is having to pay for access to public documents. And that we don't the Supreme Court doesn't necessarily have control over. And there have been proposals in the legislature that have assigned costs to document access as a way of helping pay for the equipment that it takes to be able to let you stay in your office and look at the stuff. So we control most of the stuff. We don't control everything, and we certainly don't control the revenue generating part of it.
You mentioned there will be a group getting together at some point to discuss costs and fees. I hope it will include
Right.
the media in there as a representative somewhere to have part of that discussion.
November 27th at 1:30. You can be there.
Where?
KPA too.
Can I just follow up on that?
Sure,
I mean,
please.
The federal system also has costs for the media and others to access the documents, in part because we couldn't have gotten it done without the money that is being raised for those. And although all of you should know, if you don't, that on our District of Kansas website, all of the opinions, anything that is denominated by the trial judge as a written opinion is uploaded automatically to our website, and you can get access to it at no cost anytime. So.
Okay. I'd like to just make sure that anybody in the audience who has a question feels as if he or she can ask those. So go ahead, Ron, and then we'll take questions.
Tim, what is a PACER cost these days?
The PACER cost is 10 cents a page, and when you access it, it will show you what the cost is to obtain a certain document. If you don't get more than $15 worth of charges in a quarter, don't hold me to that, but I think that's the right number, you aren't billed for those. So minimal users don't really end up paying anything. It's the big consumers of the PACER service that end up paying most of the bill.
Okay. I think we had a question here.
I just wanted to say I appreciate having the documents that you can view online on PACER. And my question is probably for the Justice or Mr. Keefover. Right now, I think it was like 3 or 4 years ago that district court clerks started scanning all court documents. I was wondering when those will be available online. Some out in western Kansas will say, you're welcome to come use the public computer, and it's several hours away. When will those be available online? Do you know?
And generally, they'll email them to you, right? If
Some do, some
yeah.
don't.
Like I said earlier, what we intend to do is start talking about that. Now, this meeting in November, we're really talking about filing fees and that sort of thing, but document access may be a part of it. But the actual system, how to make that work, is a little bit further down our ladder right now than just getting e-filing implemented. So we kind of talked the other day, because I knew it would come up here, that we thought in the middle of next year, July, August of 2013, that we would start talking about how the system needs to work in order to let you sit in your office and look at stuff over the internet like you do your bank records and everything else. But it just hasn't been as high a priority as these other things for us.
Okay. Mike, you have a question?
Yes, first for Justice Biles and Tim O'Brien. Could you talk to us a little bit about redaction policy? From the media's point of view, of course, it's fine to have access to records, but if there's aggressive redaction of sensitive material, a lot of what the media won't appear in the electronic documents. Plus, it's possible, I think, that redaction policies might make certain information unavailable electronically that normally would be available in the paper record. So just a little bit of insight would be appreciated on how the redaction issue is going to be handled and how it is being handled at the federal level.
It's probably better to let Tim talk about it at the federal level, because we haven't addressed it yet, Mike, at all. I mean, that's just part of what, I mean, once we get to the notion of it's going to be available on the internet, then the next question is, what's available? You know, obviously Social Security numbers, things like that, but whether there's a series of weeds that you can get into that make it impractical to have access, we just haven't talked about yet. I mean, we have all kinds of cases where the record on appeal, if it were public, completely public, you'd have some problems with names and dates and that kind of thing. But from an electronics and doing that electronically, we have not worked on it.
Right, one of the big issues is that when information is redacted on paper, and then it's scanned in online, there are ways that the private information, so security numbers, financial accounts, trade secrets, can still be determined by a deft computer savvy journalist or other. So there are real concerns by the courts about how to put redacted information online, and the biggest issue is how to ensure it's done well at the court's behest by the attorneys, because a lot of stuff that should be redacted apparently online in states that have online redaction they're not following the law. So it's a struggle for both sides.
Yeah, on the federal court side, you know, I'm not sure it's as big an issue as it is on the state court side. In state court, you have all the juvenile records, you have all the marriage records, the divorce information, all of those kinds of things. In federal court, you don't have a lot of that. Obviously, the same things that Justice Biles described, Social Security numbers, minors' addresses, or addresses in particular, are sometimes redacted, but we don't see a lot of it in federal court. The bigger problem in federal court is the sealing of documents, whether a document is filed under seal or not. And obviously, like in the camera situation, there is a lot of discretion among the judges about whether to seal documents or not. I think the general consensus of our judges in Kansas, of our federal judges in Kansas, is that they really do not like sealing things and will only do it when they're convinced that it is in the interest of everybody, including the general public, to do so. So I haven't, I know that there are from time to time issues that come up and requests made by the media, et cetera, in federal court to get access to a sealed document, but I don't think the redaction or the sealing has been a significant issue.
Tim, could you elaborate just a little bit on redaction? Perhaps summarize if you can do it, the criteria for redaction, whose responsibility it is to execute the redaction.
It's the responsibility of the lawyers to execute the redaction, and our people in the clerk's office will do some quality control, and we will alert lawyers if we think there are things that should not be in the file that are in the file. And the administrative office and the courts have a list of, it's a guideline of things that they don't believe are appropriate for public disclosure. I don't have that with me, but it's the things that you would normally expect to be sensitive information. But it clearly is the lawyer's responsibility. There's a little bit of check in that because obviously if one side discloses it, the other side may be checking on them to make sure that that gets redacted, et cetera.
Okay. Any other questions?
Tim, I hate to keep you on, but as part of the court pilot program as it relates to cameras in the courtroom, did the federal courts consider at all the state model, which is to allow a pool camera controlled by the media, working with a camera coordinator? If not, is that on the horizon, or are we taking baby steps here? What are your thoughts on that?
I think it was considered, but I think we're taking baby steps. The federal court, for whatever reason, has been traditionally reluctant to allow cameras to be put in any kind of a proceeding. You know, at least at the Supreme Court, we now have the audio recordings, the U.S. Supreme Court, we now have the audio recordings, et cetera, but there is still a significant group of judges that do not want cameras. And I think one of the political things that came about in this was the realization and the assurances to the judges that if the courts controlled the cameras, there less mischief would occur. I'm not saying that that's the case, but I'm just saying that that was one of the things that allowed the pilot project to go forward. And I will tell you, we've had situations as well. In part, it's a good thing that we have control of it, although probably the problem wouldn't have occurred if the media were in charge of it. But we had a long med-mal case down in Wichita that is on our website. It was several days. One of the lawyers is a famous Detroit lawyer who had defended Jack Kevorkian. It was a big production. And about halfway into that trial, we ended up recording jurors. The jurors ended up walking in front of the camera unbeknownst to us. And you know, I was glad that we had the opportunity to edit that out so that we didn't have to have a mistrial or anything of that nature. But so it does have, again, it probably wouldn't have happened had media professionals been involved, but I think that's sort of a, one of the reasons why the court wanted to keep that control, at least at this point in time. And we don't, from a clerk's perspective, I'd rather not be involved in the process. I mean, it's difficult because we have people in the courtroom who aren't media specialists, who are turning it on and off among all their other duties. So personally, I would prefer the media model that's employed in the state because I think it's worked well.
Okay. Any other questions? Back to e-filing, are there any attorneys in the room who have any questions or comments about that system? Go ahead.
Oh, I don't have one on e-filing, I guess, but more on the cameras.
Okay.
Ron, your anecdote impressed me, the one about the first case that was televised. You talked about the large size of the equipment that was necessary then, in contrast with the small equipment now. So we can trust, I assume, that technology will continue to get smaller. That we'll have miniaturization sometime in the future we don't even see now. Plus, maybe costs will be coming down even further. You mentioned that. Cost in those days was higher than now for this kind of equipment. So my question is whether, and Ron, maybe start with you, is it feasible that at some point in all courtrooms, state and federal, we will be having streamed video in real time of every case? That will become routine. And if we could imagine that happening, how many of the problems we're talking about today would either disappear or be worse? Do you have an opinion on that?
Well, you're asking things beyond my retirement. It could be tomorrow. Yes, I see that vision. I think, I think that is a logical progression in this technological world we're living in. I mean, Justice Rosen will probably still have his quill and scroll when he retires, but Justice Biles here will probably have webcams going full time. I don't know, but as you were posing the question, I'm thinking there are a number of broadcasters in this room who, if they wanted to, could have a camera on their lapel that we'd never know about. And that's,
Until they show it, anyway.
Until the viewing audience shows it. But, I think that's a possibility. But again, it's going to have to, there's a legal culture involved that takes as much to surmount as cost or other issues. There's a whole. I remember when we had public hearings with the bar, there was a pretty good segment of the bar that never wanted to see a camera. I know a number of lawyers and judges who never want to see a camera. So, as I say, after my retirement someday, that may happen. I don't see it soon.
Justice Biles, do you want to comment?
I guess it's just, that kind of thing is way, way off. I mean, just a couple of things. right now in the administration of the court system around the state, one of our biggest problems is the availability of court reporters and being able to hire them. And so, you know, there's been a big push to try to get recording devices in the courtrooms. And that meets with mixed success, not because of anything you're talking about. It's just hard to do. People don't remember to turn things on. It's not unusual for us to have an appeal in a case that was where it was a recording of the proceedings, and so then it had to be transcribed. So then you've got those problems. Bandwidth is another one. I mean, Steve Bernstein in the back here is our e-filing guy. I mean, we're having trouble making sure we've got bandwidth to be able just to run the electronic filing system and the document management and case management the way we want. So, you know, and those are infrastructure issues that we are not in control of because of the way the court system is administered, with the counties being responsible for, sort of the buildings and the hard issues, and the state being responsible for personnel. So I don't see that happening, you know, in my lifetime. So.
Kent?
But if the overall premise is to make the courts as open as possible, forget the media for a minute, for the general public, I would think what Professor Couch just said should be the goal of any court system, of the state legislature who's going to have to give you the money. Because I think what happens, now I'll get back to the media, you know, this is not just broadcasters. I mean, virtually any newspaper person in here, their newspaper is probably putting video online. And so if we do go back to the idea that the general public should have as much opportunity to see inside a courtroom, whether it's in their community or at a Supreme Court, then the more opportunities that they have, i.e. broadcast websites, newspaper websites, blog sites, your own Kansas court sites, then I guess I don't understand why we can't sort of push that ball down the field a little faster, and I don't mean before your retirement, but maybe before your retirement, because that's really what I think this should be about in the first place.
And nobody can disagree with that, but what does it mean? I mean, in the 4 fiscal years that have occurred since I've been on the court, we've shut the courts down for a lack of money in 2 of those fiscal years. And in, 2010, if we hadn't had some last-minute stuff, we would have been down, we'd had to close for 30 days. And, okay, so right now, we can't get enough money to stay open. And so what are we talking about with wanting to have more equipment so that people can tune in? I mean, I don't disagree with any of the goals. It's just that the environment is such that those goals seem unattainable.
But it sounded as if through the 2 panels we've been discussing more of a practice and cultural issue than a financial issue. For example, in the first panel, there was, the discussion about these rules, Rule 101, in which there's a question about whether the presumption is that all courtrooms should be open and that the judge would make an exception to close as opposed to the other way around, where the courtrooms are not open, for electronic devices. And so I think Kent's question is based on the idea that, is the presumption that access should be paramount, whether you're physically there or outside? I think that's the question. Go ahead.
The interesting part of your point, being that it's really the legislature that controls your purse strings, is that a lot of the people who are asking for less government spending are also, many times, we find out at the legislature, are the same people who are very adamant about open records, open meetings, open courts. So this is not a political discussion, but somewhere those people need to be, again, pushed along the way, that as you sit and decide that the courts don't need enough money, you need to also be thinking about the courts are going to need a lot more money to open up the courts the way some of these same legislators talk about. So. That wasn't a question.
I'll answer it anyway. One of the things that's fascinated me has been, during this financial problem, has been how electronics and this electronic filing and case management thing could be so beneficial to rural Kansas, because we have people that rightly point the finger that say, you know, you've got clerks in courthouses that don't have a lot of activity, and so what are they doing? And we say, you know what, if you just let us have this fancier electronic and document management system, we could have a clerk in Meade County actually helping the clerks in Shawnee County file their cases. And then you don't have the problem of somebody being out there and not being busy all day. And yet, we don't get support from the same people that say we want to keep our courthouse open out west for systems like that. And the reason is because it has a price tag. And so everybody's got a different view of common sense, but mine is that this electronic stuff, just like it helps make it more accessible for you guys, could make the court system much more efficient and still serve the social goal or the public policy goal of keeping courthouses open in all the counties. And so, the legislature has to begin to decide, do you want one judge per county, which is an inefficient way of operating, and just pay for it, or do you want us to be as efficient as possible? And those are discussions that occur in school, how many school districts you have in Kansas and all of that. But, that's the debate that keeps going on, and you just have to keep making your point. But mine would be on the court system, that those are the kind of things that we ought to be looking for.
Well, thank you very much. You've been a marvelous panel, and Justice Biles, you've been a good sport. Thank you.